Welcome, everyone, to the National Center for Technology and Dispute Resolution's ODR Cyberweek, and this is the roundtable discussion on what's on the horizon for ODR. We've got a powerful set of panelists and experts from around the world, and I just want to say that it's an honor to have all of you join us. There are a lot of busy things, important things going on in the world, but thank you for the time that you are dedicating, everyone on this call, to both participating and many of you presenting during ODR Cyber Week. So without further ado, I want to invite Ethan Katsh, who's the founder of ODR and the founder of the National Center, which is frankly a misnomer. We have 50 fellows from around the world. But let me invite Ethan to start us off. As you think about what's coming on the horizon, please share your pearls of wisdom.
Good afternoon. Although it's hard not to wish for a better afternoon. I'm sorry that my friend, co-author, and colleague, Orna, is not with us as she has been for the last 20 years. In any event, I wish her and everyone in conflict areas of the world peace, safety, and hope for them and their families. I'm sorry I've never been in a position of beginning this way, and it's a sad commentary on where we are. In any event, what can we say about the future of ODR with confidence? Colin showed me this morning that he or Leah can provide everyone with a link to Cyberweek 1998. It's worth taking a look when you get a chance because it was an extremely rich program. For a second, I felt like I could substitute that program for the one now, and you might not know the difference. In any event, but the problem was the pace of change was disappointingly slow. For most of the last 25 years, I was told that dispute resolution had to be face-to-face. I'm not told that anymore, but it's largely the last 2, 3, 4 years, COVID basically, but this has not been true. In 1998, there was email, but I was often told that the risk of confidentiality was too great for email to be used. I started out in the law and technology field where adoption of technology was slow. The adoption of technology in the dispute resolution field has, in my mind, been even slower. I'm sure that in the coming years, we will have new tools, particularly in the areas of AI. But the main element of the future, the element I am most confident will be true, is that the pace of change is accelerating. The future will be upon us more and more quickly. This change will have really two main facets. The first being the adoption of new tools for ODR, and the second being accelerated change in society more generally, which does mean that disputes will be increasing as transactions increase, as relationships increase. And when all that happens, the need for ODR accelerates as well. So I think I'll probably take my 5 minutes. Leah, turn it over back to you.
Thanks, Ethan. I do want to invite people to put comments or questions in the chat. I'll leave it to each panelist whether they'll engage with those, or we're certainly going to take time at the end of all the brief presentations to engage in dialogue with each other, with everyone on this call. So next is Morenike Obi-Farinde.
Thank you, Leah. Hi, everyone. Well, before the pandemic, just like Ethan had said, in Africa, there was such huge skepticism about the use of technology for dispute resolution. And of course, we have our infrastructural challenges and all. And so the thought of having dispute resolution online seemed like an impossibility before the pandemic. But then, thanks to the pandemic, we saw that we had to swiftly move our processes and our dispute resolution both as practitioners and even the courts. And what is more interesting is that because the courts had to move online, it actually accelerated the acceptance of using technology for dispute resolution. So we had courts across Africa, in Kenya, South Africa, in Nigeria, swiftly using, of course, most of them use Zoom to have their cases heard across the continent. And this, they actually found, helped the administration of justice, both criminal and the civil justice systems. So now what we have in most of Africa is that we find that courts have incorporated into their rules of practice the possibility for online resolution and online justice. And this has, of course, given credence to the use of technology to improve access to justice across the continent. So for instance, in Lagos State, you can actually file, not fully, it's not a full online court, but you can actually file your cases from the comfort of your offices. Of course, we still have some hiccups here and there, but then we also have things like accepting service of court processes by WhatsApp, by email, either to before all of the advent of the use of technology and ODR. We didn't have all of that. And you had to like maybe advertise in newspapers or actually post at the entrance of the last known addresses. But then we have even seen the ingenuity of some judges who, for instance, there's a state in Nigeria, it's Enugu State, and there's some areas of Enugu State that you cannot travel to because there's security risk, there's kidnapping, there's robbery. And so what had happened in the past is that those courts have been abandoned. And then we had had like a few years of nothing happening in the correctional center. So what it meant is that people were just locked up on end. But then we've had a few judges come up now who have been able to use technology to surmount those security challenges. And this has, of course, helped the administration of justice. And because of this, we see more judges taking the initiative to use technology to better improve access to justice across their states and across their state. So in essence, despite the challenges that we have across Africa, we see ODR evolving in a way that we can adapt with our culture and in a form that our infrastructure can sustain. Of course, there will be itches, there's sometimes hiccups, but we're able to manage it in a way that at least improves access to justice. So I see more of that, and possibly even the states accepting and assimilating more into their formal systems the use of ODR in the courts. Thank you, Leah. I think I'll stop for now.
Thank you, Morenike. That's powerful testament to what's happening, to the creativity that the courts are picking this up, and also maybe points out some of what Ethan was saying about how it's taken a long time for courts in most parts of the world to pick up on applying technology in these ways. Mirèze, Philippe, please.
Thank you, Leah. I will start by saying that we walked on the moon. Justice is not yet online. And why do I start this way? Because we can probably mourn about the hundreds of platforms built since over 2 decades now, which were interrupted mainly for the reasons I will address. We learned on October 17 that the European Commission adopted a proposal to review the ADR framework and, among others, to discontinue the ODR platform and replace it by user-friendly digital tools to assist consumers in finding a redress tool to resolve their dispute. This announcement has triggered discussion in our NCTDR group and a lot of sadness. Apparently, one of the reasons for which this decision was made was the massive lack of use of the platform. So this is, in my view, a wrong issue, because we know the problems that I will address in a minute. What we actually observed is that the Commission made some efforts but never seriously committed to ODR, and no one really bothered about making significant announcements or educating users and so on. So speaking about the horizon without addressing reasons for which online justice is lagging behind will not help much in my view, and I wish to raise them very briefly. The main reasons for our disappointment can be summarized as follows, and these are the points I wish to put forward for discussion. So the undeniable mistakes in my view, first, the points about discontinuing the EU ODR platform, which was predictable in my view, is that the platform was a misnomer because it's not ODR. It was only a platform presenting the ADR providers and available only in Europe. If a consumer filed a request, it was directed to one of the organizations. Pablo can maybe better speak to that. This is unfortunately not the first time the EU fails, as I say, consciously or unconsciously, in building platforms for consumer disputes. They had also dismantled for no reasons two previous platforms. The first one was EcoDear platform for consumer disputes, which was user-friendly and worked very well back in 2000. And the second one was EEG.net, and now the EU ODR platform is the third attempt, which is no longer available to users. So we are in 2023 and nothing has unfortunately evolved. And before addressing the other points that I have been raising for the past decade and which are related to recurring mistakes and lack of serious project building, I will start with a general remark. NCTDR and ICODER have been militating for justice online for at least 3 decades. Access to justice is a human right. Impeding access to justice equates to denial of justice. Governments, courts, dispute resolution organizations must give access to justice to people who have no remedy, either because of low income or remote locations or disabilities, cross-border disputes, and so on. And providing remedy is not just a human right, it impacts business. And this is something that I think most business developments have not sufficiently understood. The entire society and the economy is also in general impacted. So the recurring issues are mainly when building dispute resolution platforms, which is no rocket science. The major problem is first the willingness of all stakeholders, governments, organizations, dispute resolution organizations, consumer organizations, merchants, to give access to justice and to properly invest in long-term projects. It is indispensable to have any platform project supported by all stakeholders. Otherwise, when successors of such structures, whatever organization it is, come on board and this project is not on their agenda, they will simply kill it and want to have their own project. We do everything online, from buying the sandwich to launching satellites. So it's inconceivable that in 2023, everything is available online except justice. We know that only a few platforms work in the US and Canada, so you're lucky, but not everywhere else. Now, in the business plan for building a platform, the most important issues which may contribute to the success of a project are, first, making a proper market survey and approaching all and various profiles of potential users. When drafting specifications, involve end users, organize pilot projects of users who represent various groups of given population, conducting proper testing with the pilot projects and pilot groups, and make corrections to try to get to a satisfactory result before the launch. Once launched, ask for feedback and ensure that upgrading of the platform is possible, and ensure that users are informed that their expectations have or can be potentially met. And during the building of a project, communication about the project regularly is one of the utmost importance, because otherwise people will not learn about it. And then we need to educate people. So other also recommendations I would say is to stop being bystanders and wonder whether justice online is possible. It sure is. We've proven it over the decades. We must never build platforms and then interrupt them, because continuity is essential. People think that it's science fiction. It is not. We have proven that it exists and it works. And if we interrupt platforms, people will not use it and will think that we are still trying to understand how to provide justice online where it exists already. Limiting the project to building a platform is also a common mistake. Long-term business plans and proper budgeting is essential. You don't throw to the trash, as have been done with hundreds of platforms just because they need to be upgraded or there are some bugs or any other problem. You invest, you budget properly, and you take it forward. Neglecting time and effort for drafting detailed and clear specifications is another problem. We must also be realistic. Of course, we are ambitious, but we need to take projects by steps. And proper communication and marketing is so important. No one really, except the Colombian court platform, no one publishes reports about the number of cases, how they have been settled, and so on. You provide confidence to users by showing them that filing a request online and getting proper remedy, if possible, is possible. And if merchants do not publish reports about the cases they have settled or not settled, but what happened and the reasons for which it happened, the users or the buyers will not be encouraged to go again on the merchants platforms and to continue business. So there is a lot to be said. I will stop here. Publishing hard data to assess progress and provide analysis, contribute to convince users, and educating users is of the utmost importance, but also having really governments and infrastructures commit and be willing to take projects forwards and not kill them. Thank you.
Thank you, Mirèze. You shared so much rich insight about the past, about what's possible, about the future. And I just want to kind of highlight a couple things, but there's so much more there that you said. You brought to the table the idea of education, of systems design, and of the role of governments, whether they're regional bodies or states. Thank you very much. Dan Rainey, next.
Thank you. Well, let me start by echoing Ethan's wish for peace and safety for everyone, everywhere. Sorry to have to say that, but that's where we are. So I'm not going to surprise my colleagues by coming at this from rather left field. This has been my week for thinking about where we're headed as a dispute resolution community. I spoke this morning to a group from the National Academy of Arbitrators about what's happening with technology and where that's leading the field of arbitration. And then this afternoon, we're talking more generally about online dispute resolution, where we're going. And oddly enough, what's made me think about is a publication from 1658 entitled The Annals of the World. It was published, and in that publication, James Usher, who was the primate of Armagh and a vice chancellor at the Trinity College Dublin, did the calculations and figured that Adam and Eve were kicked out of the Garden of Eden on Monday, November 10th, 4004 BC. Very specific. And a colleague of his, who was also a vice chancellor at Trinity College Dublin, did more calculations and figured that it was 9 a.m. in the morning on that Monday. Now, why am I thinking about this? It doesn't make a lot of sense. Why I'm thinking about it is that we have for a long time been in a fairly predictable world in terms of fourth parties and third parties. Ethan and Janet Rifkin back in around 2000 coined the term fourth party, and that to me has been a key thing to think about in terms of thinking of online dispute resolution, that you have a human being who is in some way or another in charge, and then you have this technology that is a fourth party operating somewhere on the side, but certainly affecting the work that we do. And of course, Colin, who has been called the godfather of online dispute resolution, created the poster child for moving the third party into a fourth party position when he was working with eBay and PayPal. Millions and millions of disputes resolved without a human interaction because of the bounded universe that they were operating in. So when I think about where we're headed, I'm not going to suggest that we've been in the Garden of Eden, but what I am going to suggest is that we are rapidly moving out of a fairly controlled and bounded universe of online dispute resolution, third and fourth party relationships into a new world. And I'll give you a very quick example of something out of my past. When I was at the National Mediation Board, Ken McGill and I created something called the Knowledge Store. The Knowledge Store was several decades worth of arbitration decisions in the railroad industry that were searchable, word searchable, so that if I were preparing an arbitration case, I could type in a term, order of call, or whatever it might be. And I actually did this the other day and got over 1,000 hits on order of call. Now, that's helpful because I can now know who was involved. I can know the arbitrator who was involved. I can read the decisions, the awards that the arbitrator put forward. But essentially what that fourth party has done for me, what online system has done for me is it's given me a ton of data that I have to deal with now as the third party who's going into this situation. If I were at the National Mediation Board now, I would be working with AI so that if I were using this data set, I could say, write me a draft argument using the arguments that have succeeded with this particular arbitrator in cases that resemble this one over the past 5 decades. And within a matter of moments, I could have a well thought out, targeted document that it would have taken me forever to do if I could have done it on my own at all. Now that's sort of a mundane example, but what it really says to me is that we've had third parties that have moved into fourth party positions in very bounded universes. We are about to be in a position where we can have third parties or fourth parties moving into third party situations in very messy, unbounded universes. And there are already robo judges and there are already robo arbitrators that are out there. And where I see we're going, where I see we're headed, is instead of having a ton of generalized AI programs that you can use for pretty much anything, there are going to be specific AI programs that target certain venues that are capable of operating in those venues in a way that is far beyond what we've had before in terms of the bounded universe, third-party algorithm-assisted work. So that's where I think we're headed. We're walking out of the Garden of Eden, so to speak, and we're headed into a very complicated, very rapidly changing environment. And predicting where we're going to go with that is a fool's game, because we can think about some of the things right away. I've had a conversation with some of my colleagues who work in litigation and arbitration, and they say, well, the first thing that's going to happen is we're going to use it for research, and we're going to start using it to write drafts. And that's obvious. What's not obvious is that as we do that, we are going to find ways to use AI that we're not even thinking about now. And so the future that we're walking into is one that's going to be very hard to predict, but it's going to change fundamentally the way we approach dispute resolution generally. And so that's my guess as to where we're going out of the Garden of Eden.
Thank you, Dan, for raising points of mystery and religion and reminding us that we could learn so much from thinking about questions that were raised in the past and also about the unknown. And you're challenging us as we're trying to talk about what will happen in the unknown to remember that so much more can happen, some that may be at risk, put us at risk, but also some new ways that we can't even envision. Thank you. Next up is Pablo Cortes.
Hello, everyone. It's a pleasure to be here. When I thought about the horizon of ODR, I thought I will comment briefly on the changes in the European Union, which Mirèze already addressed, and also about the use of ODR in an unregulated market, specifically in the dark web, because I have been doing research in that field. And it's fascinating to see that ODR can be also used to undermine the rule of law, to foster illegal and illicit transactions. And it is essential for these markets to foster. But let me first comment briefly on the revision of the European law on consumer ODR, which Mirèze has already said they are planning to repeal the ODR regulation, and they are going to replace the ODR platform with another online tool. But I think it's also worth highlighting that the directive that is linked with the ODR regulation is also being amended and being expanded to try to cover pre-contractual obligations and third country merchants. So like American businesses will also be affected by this change if it passes, if the Parliament and the European Council approve these changes. Participation will remain voluntary. There are additional protection for vulnerable consumers in terms of access to non-digital format and inclusive tools. And also when ODR providers that have been nationally approved use AI and automated processes, they must offer some level of human revision. The changes in the legislation are accompanied by complemented with a recommendation for marketplaces and trade associations that offer ODR services that they are recommended to follow the standards set in the ADR directive. But ODR obviously is also operating not only in the regulated space, but in the unregulated space. And that was something that I wanted to comment. Specifically in the dark web. As you may know, the dark web is that part of the internet that is deliberately hidden. You need to access using Tor, the onion router that encrypts the location, has different layers like an onion, and encrypts the location of the users. And then you have to identify or find the links to these illicit marketplaces or forums, because they are not listed in standard search engines. Well, naturally, access to the dark web, it's legal. It was developed by the federal government of the US, and it's a very powerful tool to uphold freedom of expression in countries where they restrict the internet, like North Korea, China, Syria, and elsewhere. But there are also illicit marketplaces that they emerge with the appearance of cryptocurrency, Bitcoin, because that enables parties to make anonymous payments, and they use a cross system. So basically, the payment goes to an intermediary. That facilitates the use of ODRs. So if there is a problem with the transaction, the payment is frozen, and then the escrow service or the marketplace administrator, they basically resolve the dispute, and then they self-enforce the outcome. Since this relates mostly to illicit transactions, mostly the sale of drugs, but it could be weapons, it could be second-hand credit cards, it could be different services that are offered in the dark web. And the characteristics of the ODR, they are quite peculiar, because not only deals with illicit disputes over illicit transactions that cannot obviously be resolved or enforced in courts, but all the users and the third parties are anonymous. The process is very informal and ad hoc. It's very fast, usually within a week. It is free. The cost is paid with the escrow, is by the fee that covers the escrow service. There is a preference for settlement over adjudication, as some previous research show, like Colin brilliantly did on looking at eBay. But there are also other peculiar characteristics, like for instance, it's very common in the dark web when there is a dispute that they open a separate thread or forum in the marketplace and invite the community to comment on what would be a suitable resolution. And even though that does not bind the third party, it sort of influences obviously the view on how the dispute ought to be resolved. And obviously, vendors and adjudicators have incentives to be fair, to get repeat business. So it is, and obviously the outcome is self-enforced of the dispute payment via blockchain. I mean, and there is a high number of disputes, and they're not always of low value. There've been reported cases of over $1 million US. So what is fascinating is that here, the goal of ODR is to increase trust, in this context, in illicit trade in the dark web markets. And in doing so is creating the emergence of a private justice system that is, is independent of the legal system. And I think it's interesting to see the different applications of ODR that operates even outside the actual legal system. And with that, I'm done.
Thank you, Pablo. So interesting to bring the dark web into the conversation. And by bringing up the issue of regulation, that opens the door for us to have more conversations around that. And also, of course, besides the dark web, there are other parts of the world outside of the EU that have unregulated spaces for both ADR and ODR. So thank you for bringing those topics to the table. Our next speaker is Noam Ebner.
Thank you, Leah, and I will try and face the challenge of going, I don't know, 6th or 7th in this group of billion people and actually having something intelligent or original to say. I'm going to do it to the extent that I will. I'm going to do it by piggybacking of some things that Dan said, particularly of some things that Ethan said about the notions of resistance to technology and adoption of technology, which are things that I've been looking at, not only in ODR, but sort of ODR writ broad to include all of, let's call it, let's say ADR and ODR, and I'll talk to both of those. And with the acceleration in the pace of change, and so I'd like to toss back, not as far back as Dan took us, but just to 4 years ago, where I wrote an article with Allison Carroll from Northwestern called Mind the Gap. And in Mind the Gap, we in a nutshell, we said two things. One is that mediation, traditional mediation, needs to adopt technology or it will wither as a profession, as a field. And the challenge to that happening is what we called the gap, which was that ADR folks thought that ODR folks are in charge of developing technology for dispute resolution processes. And ODR development wasn't focused on technology for use in the mediation room or for supporting mediators who were going to mediate in the mediation room, with a few small exceptions. Some of them were larger in case management software, for example, but largely ODR was focused on what happened out there in systems. And the closest it came to traditional mediation was largely replicating it online through email in the early days, through video. How can we put this online and hold an equivalent process online? It wasn't about how can we technologize the mediation room, again with some specific exceptions to that rule. And when COVID came and technologized everybody in mediation, so I wondered, okay, is this going to close the gap? Our mediators now, when they do go back to the room, are they going to say, okay, well, we're technologically savvy, now let's start thinking about how technology can help us in mediation? And it turned out that no. If you ask that question to mediators, okay, now that you know that the technological lion it's not so, nothing to be afraid of. So how are you going to use technology besides replicating processes by Zoom? How are you going to incorporate technology into your mediation practice? And the answer might be something along the lines, well, now I'll have Zoom meetings in between mediation sessions for face-to-face processes. What other technology? Again, with another couple new exceptions, very, very little. So that was not the technological gap closing. And I'm going to suggest that I think that generative AI, which has been talked about and we'll continue to talk about it throughout the week, it might turn out to be the close the gap technology in terms of its ability to serve as tech in the room, physical rooms, or tech for the room for processes that are very much face-to-face. And some of the why is anecdotal. I know that some of you have done this much more than I, but when you actually demonstrate this new generative AI to groups of dispute resolution professionals, I see faces light up. And I don't think it's my delivery or my charm, okay? Faces light up and there's none of that. There's enthusiasm. There's, oh, I bet we could. And none of that sort of, this will never work, or sort of that uncomfortable turning away, shifting in their seats that we've all experienced with other technology. And generative AI is also the technology that's been adopted and put into use most rapidly by the ADR field. And I don't mean that in the sense that all mediators are now using AI. No, I mean it in the sense that that you now see people who are not, we didn't know them inside the ODR field a year ago. But now they are either, making suggestions or putting out videos and perhaps actually leading different projects or different ideas for how to implement technology, generative AI, in mediation processes with an eye towards mediation as it has always been in the room. And Ethan talked about how long it took, to overcome the resistance to email, right? And so I won't go over that, but Zoom, like, I don't know, Skype launched in around 2003 or 4, and Zoom in I don't know, I don't want to point to Colin and say, you tell me, 2012 or 2011. And if it weren't for COVID, most mediators would still not be using Skype and might not have heard of Zoom. So we have that resistance before adoption cycle with all technologies. And with ChatGPT, when it burst onto the scene about a year ago, it took around 2 weeks at most before people started, and not us, okay? People from the mainstream mediation field started thinking, how can we use it? So that's going to have many ramifications. One of those is that I think we're about to be joined in these rooms by a new wave of people, some of whom showed up when Zoom became a thing, and then all of a sudden our crowds expanded, and then people went back to their rooms to some extent. I think we're going to see a new wave of fresh fields relating to our field. And secondly, and this is more interesting to me in thinking about the field, is that this is going to change. It's going to change dispute resolution, both online and offline, in different ways. And I'll say this in the briefest of all ways, because that was my 4-minute warning. And the first is, as Ethan said, more disputes, right? And Ethan wrote that up very nicely. It was true 25 years ago. It's true today. More and more disputes. The second is a theme that I've written about in an article called Negotiation is Changing, which I've spoken about, which is the more we get immersed in technology, the more we change as humans. And I won't get into that very deeply right now, but I will say that Ethan pointed out that the pace of this technological change is increasing. And the more the pace of technological change increases, the greater and faster and deeper the change processes we go through. And so we'll start to see vital elements, or elements vital to conflict, begin to change. Trust is not necessarily the same thing it was 10 years ago, or the way we build and form trust. The notion of what is a fact is not the same today as it was 10 years ago. So what does that say for objective criteria in conflict or negotiation? What does that say? Well, critical thinking, which is something that I'm sure that generative AI will change in the way we approach anything, a document, a statement. Wait, is this generated? Is this wrong? Is this an AI hallucinating? That will change the way we think. It will change the way we fight. It will change the way we resolve ultimately. And my second comment is less about broad human change, and it's more about professional change. And this is that the more we use technology to facilitate or support processes, any processes, online, in the room, mediation, or anything else, technology winds up changing those processes. Okay, just ask anyone, if you haven't done this yourself, ask anyone who has dated online. Okay, it is seemingly the same, but fundamentally different in so many ways. And what happened was technology took this process of people getting to know each other and connecting and bent it in different ways. And I won't get into that. But the same, some of it was intentionally done by the designers, and some occur as practitioners, whether they're daters or mediators, sort of bend their processes in order to suit the fields, right? There's a field to fill in, so that's where we're going to aim. And so there's the possibility, and I'm not saying danger, but the possibilities, because I want to be neutral in all this, but there's the possibility that our familiar processes are going to change, perhaps because we'll be able to access outcomes that are typical and average. Maybe we'll focus less on tailored, bespoke, personalized outcomes. It might be that because technology offers so many robust means for evaluation, right? Give me the average number of all of the settlements that were in X court in Y year. So we will aim towards let's direct people or evaluate towards that instead of working on facilitation. I have no idea where this is going to take us, but I do want to just say that those two areas of human change and of process change because technology bends us, that's what I'm going to be scanning the horizon for.
Thank you, Noam. And I'll leave the summary that you just gave standing, but also note that you brought the idea of how technology can be impacting face-to-face processes into the room as well, into this digital room as well. Thank you. Next is Aurora Esther Vilalta.
Thank you. I'm delighted to be here today. Well, I'll try to stick to the time allocated. And as mentioned by my distinguished colleagues before, previously, we see that online platforms, smartphones, and all this technology are becoming fundamental in the everyday life of citizens to communicate, to interrelate, to access to all kinds of services, products, and online transactions continue to expand, surpassing by far all expectations, and shoppers are becoming very highly sophisticated as well. So this is basically why, in my view, people also need, and I would say desperately in some areas, sectors like consumers, they need online mechanisms as well to resolve disputes in this arena. And we all know that ODRs are not a panacea for all kinds of conflicts, of course, but they increase effectively the access to justice. So I would like to add to this conversation some reflections related to a question that I have been asking to myself for some time, okay? And this is why ADR and ODRs are not yet the mainstream channels of dispute resolution. In other words, are they being taken seriously or simply resorted opportunistically by states when things get really bad? Let me just expand a little bit on this by saying that ADR and ODRs have been showing their benefits for more than 3 decades, Mirèze said. However, they have found a plethora of difficulties. On one hand, a clear lack of knowledge and some distrust on the part of legislators, on the part of the judiciary, and on the part of stakeholders of justice. On the other, the lack of real procedural incentives and benefits to those who opt to ADR and ODRs when they eventually need to resort to the courts. And finally, the great inconsistency between what the states and policymakers formally proclaim. They want a holistic and digital justice systems embedding ADR and ODRs, and the scarce financial resources devoted to their effective implementation. And the fact is that the states still resort to ADRs almost exclusively when courts are not able to manage all the claims. Just to give an example, it happened in 1906 when in the academia, Roscoe Pan gave his, this iconic speech, The Causes of Popular Dissatisfaction with the Administration of Justice, and also then years later in 1976 when Warren Burger, Chief Justice of the Supreme Court, convened the Pound Conference to explore this opportunity to include ADR, into the justice systems. And more recently, we saw it during the pandemic with the lockdown and the accumulation of files when ODRs harnessing the momentum alleviated much of the problems of court delays. But then unrealistic budgeting for pilots and programs coupled with provisional regulations made them unsustainable once the lockdown was over. So as to the question posed to this panel, I would say that many developments in the field of ODRs are in place thanks to artificial intelligence, blockchain, machine learning, and many other technologies applied to dispute resolution. But to be realistic, right now, in some states like, for example, Spain, we see a slight slowdown in the pace of digital transformation into the public sphere because of this financial issue. So one immediate milestone may be to preserve and consolidate ODRs that have managed to find their place during the pandemic, offering online access to justice, because the pandemic has proven that the use of ODRs can greatly enhance the access to justice. So, and the second milestone would be to clear the path for ADR and ODRs. And how? So the second question would be how? And I would say that basically addressing these 2 or 3 issues that I mentioned before. First, increasing the pressure on public institutions to consider ODRs not just a means, but a crucial objective into the future holistic and digital justice system, moving towards greater integration of ODRs with appropriate budget allocation as well. And the UK, it's a good example of this. Secondly, claiming for bold legal frameworks that include real procedural benefits to those who resort to ODR, ADR and ODRs, considering as well mandatory obligation to participate to repeat players who produce the vast majority of claims, like in consumers transactions, traders. And third, public policies for a genuine cultural transformation. And for me, it's the most important, incorporating the logic of ethical values among citizens and stakeholders, coupled with ethical standards of practice for providers. And I have to say here again that it's worth to mention the work of the National Center of Technology and Dispute Resolution under the leadership of Professor Leah that has already done a brilliant job. And finally, the close coordination of efforts between public and private institutions to produce sustainable online environments where citizens may access to resolution services with no need to set a foot in a court as a rule of principle, because they are able from digital portals to access to ODRs and to courts directly. And also where the one-time principle is made real, so that users of justice do not have to reproduce again and again the data related to the case every time. And where the data may circulate safely and directly between the different instances through APIs. The application programming interfaces. So in my view, only the conjunction of these factors will allow, from my perspective, the real taking off of ODRs. And just to, I will stop here just to say that our societies have changed. So if justice systems should reflect the values of the communities to which they serve, they need to change as well. And I would like to recall the words of the Chancellor of the High Court of the UK last July, as he was explaining the purpose of this holistic digital justice that they are building in the UK. And he said that it is not reasonable to deprive our citizens with digital capacity of processes that are more appropriate and efficient for them. Thank you.
Thank you, Esther, very much, not only for highlighting the importance of the changes that are occurring in culture and in technology in our systems of justice, but also reminding us of the importance of public funding for these efforts. Thank you. Next up is Colin. Rule.
Thank you so much, Leah. Hi, everybody. I'm delighted to be with you here at another Cyberweek. I remember back, actually, the 1998 Cyberweek, and I just want to take a moment for us all to reflect on how far we've come. I think it's easy to be frustrated at the slow pace, but I actually think it's amazing to think what we have achieved. We now have something like 80 plus some odd courts in the United States that have deployed ODR in some form or fashion, some slightly more sophisticated, some more primitive. I think even the fact, it's very sad that the EU is pulling the ODR regulation, but the fact that the regulation existed in the first place, I think, is a huge testament to a lot of the work that we had done to surface the prominence of ODR, and all of the work that we did in UNCITRAL, I think eventually extended to APEC and the ODR standards for cross-border B2B transactions, and now to the ISO. So I think that we have achieved an enormous amount in making ODR common parlance. Actually, I liked what Pablo said about a private justice system. And I think that we often don't think about ODR necessarily as a private justice system, because I know, Pablo, you and I have had conversations about whether or not ODR should live in the public sector or in the private sector. But I do think, and this is a point Esther made as well, technology is advancing rapidly. You know, none of us in the ODR field invented any of these technologies, AI or mobile phones or Zoom or any of it. We didn't create any of this. We are very much an applied field. So we're trying to take these innovations and developments and then put them to work at the shared common purpose we all have, which is trying to expand access to justice, access to fast and fair redress. So I think we've achieved an enormous amount, and I'm so proud at what we've done. I remember in 1998 we were discussing what to call the field. So even the fact that we came up at a Cyberweek with the term online dispute resolution, and Ethan wrote the book, and now it seems all over the world people talk about ODR. Just, oh yeah, of course, ODR. I think that that's an amazing achievement. But that's looking over our shoulder at the mountain that we've already climbed. But I think if we turn back around, we see there's still much scaling left to do. And Morenike and I were just engaging in a private chat about some of our frustrations trying to get traction with some of our ODR experimentation. We all have seen lying alongside of the field the rubble of failed ODR ventures, people that weren't able to, keep it going. And even to this day, I think there are ventures that, again, are continuing to fail, even though we talk about how ODR is growing and awareness is expanding. Mirèze and I have talked as well about great platforms that entrepreneurs have created, put a lot of resources, time, and money into, and they just can't find a market. So, we certainly have a lot of challenges ahead of us. But also building on what Noam said, I think AI is a whole new frontier for us. One of the first ODR meetings I attended was the ICAO conference in Edinburgh. I think Ethan and I were there together. And that's where I first met John Zalesnikov. And I think the AI community has been working on this for even longer than we've been working on ODR. And now suddenly these tools have become, front and center. So when we talk about the big picture of expanding access to justice, building a private justice system, leveraging technology to help people achieve fast and fair redress, I think AI is a huge breakthrough. And I think we are witnessing in real time the norm changes around the world as people wrap their heads around this tool. So we are going to have to figure out not only LLMs. I think ChatGPT is the one that's sort of the icebreaker that's changing a lot of public attitudes about this, because anybody can log into ChatGPT and play with it. But there's a lot of other kinds of AI that are even more powerful that are behind the scenes that we're going to have to reckon with. So I also applaud the great work that Leah and Dan and others have done with iCoder and creating standards in the field and integrating in AI. We are the repositories of expertise on this. People come to us repeatedly. I'm sure all of you are giving presentations all the time on ODR because people are so curious about it. And I think we take the ethics of the work that we do very, very seriously. But I think that we are on the cusp of a giant new wave to push ODR forward. And I think I said in my book, ODR for Business, back in 2002 or whenever it was, ODR is inevitable. It is inevitable. And that's what Richard said in Online Courts and the Future of Justice. The entire justice system is going to digitize. It's just taking a lot longer than we thought. And it's very much, this is what I said to Morenike, 2 steps forward, 1 step back. So we have to keep charging. And, I think we've carried the torch for a long time. It's so exciting to see the younger generation. A couple of us were in Bangalore, and to see 500 people, the average age in the conference was 29. The passion these people have for ODR, using technology to expand access to justice and solve problems in the legacy justice system, it's incredibly exciting. And they do see themselves explicitly as standing on our shoulders and the work that the field has done to date. So this is not a small project. This may be a multi-generational project. None of us are going to see the end of the work that we all began together. But I think we have a lot to be proud of. And I always enjoy Cyberweek because it really sets a marker in the sand to say, where are we today and where are we going? So I'll leave my comments there.
Thank you, Colin, for, again, looking forward as well as backward and reminding us of the accomplishments that have already been brought forth over the last 25 or so years, and also highlighting the fact that there's a whole younger generation that isn't just curious, that they're already picking up the mantle and creatively in entrepreneurial ways developing new theory and new ODR platforms. So I realize we're coming up against the hour. I have a couple thoughts. I'll try to keep them shorter than 5 minutes. And for those panelists and other participants who can stay on, maybe we could take about 10 minutes to have a chance to have some engagement. So I guess when I think about the waves that I see in front of us, One of them builds on something that has been a theme in the conversation so far today, which is about AI. And I think actually AI and other forms of technology are going to increasingly alter what we see still as silos between ODR, ADR, and courts. And I think that diffusion is going to be incredibly exciting, open up new possibilities for transforming how we deliver services around repairing relationships, solving problems, and access to justice. But I also think I want to build on the point going back to Mirèze around human rights, and something that Ethan and Dan brought up around war. It seems to me that humans, unfortunately, have used technology in cruel ways, everything from genocide to cyberbullying. And I think that when we add the enormity of AI, that we will see more cruelty, more brutality, and more violation of human rights through the use of technology, whether it's as we employ technology in face-to-face dispute resolution, or whether it's online. And as a result, I guess I really appreciate Esther asking our field a question and the questions that she asked. So I'd like to ask us to consider, as we try to help develop the future, not just live through it, what can we do so that the bias that already exists in machine learning, in platform design, I'm not talking about ODR platform, but in general, in platform design and in AI, bias is baked in to the way data is collected and managed. Why is it going to be different? And what role can we play so that it's different? So when AI adds steroids to our processes and alters them, as Noam says, that we are not replicating bias and adding to harm doing. That's one thing. The other thing is, I think it makes the urgency for guardrails and best practices, standards and principles, all the more important. So we do have some efforts underway in the Center and iCoder, and we're glad that they are starting to be used. They're embedded in the APEC document, and other organizations worldwide are utilizing them, but they're living processes. And so we hope that you'll continue the conversation about standards. And I do want to say one last thing, building on what Colin said. I think we need the younger generation that has grown up with technology to bring their best efforts forward. And so increasingly, who's online when we have these conversations will be multi-generational. And I know there are some young people online now, and you're very welcome. So with that, as we turn to have a conversation with each other, I just want to remind folks that there's a full Cyber Week with 4 or 5 events every single day. There are student panels. There's a simulation that starts right after this. There are ODR platform demonstrations and incredibly exciting presentations. I do want to thank in particular Texas A&M's Law School, as well as the Society of Mediation Professionals in Singapore, who are both co-sponsoring some events. So with that, let me open it up and see if there are questions or comments. Let's start first with participants. All right, well, participants, you feel free to raise your hand and jump in. In the meantime, then, I think Ethan had your hand up, and then Mirèze.
Yes, I just I think I needed to mute. You hear me? Thank you. One of the things I realized when listening to this really thrilling conversation in a way was my feeling that we've undercounted the use of ODR by focusing first on where we didn't undercount it, namely eBay and e-commerce. But there are all kinds of places where ODR is used that we don't pay much attention to because they're not millions. They're single cases, maybe many single cases. And some of you have heard this example from me recently, but I'll take 2 minutes to say it again. I on my flight to Montreal for the ODR forum, at the TSA X-ray machine or whatever it is. I left my raincoat there, and it was annoying because I could have walked back a half a mile at the end from the airport, but gotten it, but I didn't. I knew my wife was going to be furious at me for doing something stupid. But then I realized maybe TSA has an ODR system, and they're the last people I would have thought would have an ODR system. But lo and behold, they have a website. They ask if you've had any problems. They ask if they have a lost and found, and they have some forms online. And this morning, my raincoat arrived. Cost me a few dollars, but still, I'm still in a quandary whether to tell my wife about this or not. But it caused me to just think every government institution probably uses ODR in some way, maybe a minor way. Maybe it's a, $25 kind of claim, but it's embedded in there. And once it's embedded, there's no taking it out.
Thanks, Ethan. Again, welcome any participant or panelist, put a question in the chat or raise your hand. Mirèze.
I would like to pick up the comment about private justice system. And please correct me if I'm wrong, anyone connected. I think that we all started with actually private justice before even trying to address public justice, that is with the courts. And that's how all the platforms started to be built before getting to convincing courts also to have ODR platforms. But the problem with the private justice system is, again, to have financial support and support from governments who accept, and courts also, who accept to support projects and to promote them, because you need to give confidence to users that it's not something aside that will not be recognized and that you have to start all over again before the courts. So private justice is really where we started, but then we need all the stakeholders to support. Otherwise, it will not work, because we've seen now in the past 2 decades that many projects failed without the necessary support.
Thanks, Mirèze. Michael.
Mute. Hi. I just wanted to say in November 18th, I and director of NCTTR and Morenike, you will go to the iGroup on ODR, right? iGroup, Inclusive Global Legal Innovation Platform on ODR. It's short for iGroup, means I give lip service. It's easy to remember. And I think our ODR, NCTDR fellow, not just like the state together talk about it. We go to the OnSitio. We go to iGroup on ODR, because that platform give a proposal to OnSitio. Yeah, the general secretary of OnSitio and Anna, right? We'll go there. The head of the Justice Department of Hong Kong, we go there. So they give a proposal. So I think the ODR and is influential. Many people right now use different terminology, like for example, like a computational law, something like that. But only ODR use on ISO, APEC, and OnSitio. So very influential. So I'm like director of NCTDR, Lee Win, will wake up on the early morning, 3 o'clock, and to give a presentation. So I will follow her to support her. And I think Maureen, like you will go there too, right? You're from Africa. So I think want to not just we talk about our, we are talk about ODR in like Angstrom, APEC, ISO, Chinese court, court in Montreal, right? Many places. Make it practical. It's not just publish your paper. Okay, let me, I'm just done. And one more thing, even Li Win didn't have time to go to the Chinese garden of in Montreal, the botanical garden, but they have to make her time to wake up on the early morning to Hong Kong. Yeah, I think I'm very appreciative to treat the ODR as a region. Okay, I'm done. Yeah.
Thank you, Michael. That's very kind. And I do want to echo, there are people all over the world in different time zones and different countries and regions working incredibly hard on moving ODR forward, experimenting, trying to integrate it into colleges and universities, law schools, as well as regulation. So thank you for your comments. Anybody else who hasn't shared yet? Otherwise, maybe
Leah,
we'll take.
sorry, can Michael clarify what platform or meeting he referred to? Because I didn't get the name.
Oh, it is first, I give lip service. Okay, I is inclusive, G is global, L is legal, and I is innovation, P is platform. So for short, you just remember I give lip service is a platform. They give a proposal to Angstrom, and we had 3 conferences already, and the proposal and the document in the they want to talk about the what we have achieved in ODR and what we should do in the future about the ODR. Yeah, thank you. The iClip on ODR platform and the keywords iClip on ODR and the Angstrom keywords you can find it. Yeah, thank you so much for your.
Thank you, Michael. Anybody else? Any other comment before we close? All right, you all. I put the link in the chat in case you're interested in something else for today, whether it's your morning, afternoon, or evening. And I hope I see you in another event this week. Thank you to the panelists and participants for coming.
Thank you so much.
Thank you, Leah.
Thank you.